Hello, let's learn something about intellectual property. My name is Will Allen, and I'm going to tell you a little bit about patents today. I am a mentor in class 39 for Alchemist Accelerator. I'm a new mentor here, and I'm really excited about this role, and I've looked through all the company profiles to some extent and all the amazing things that are happening. It's quite energizing. I'm a retired HP fellow. I parted ways with HP in 2020. I was the first fellow at HP promoted in their printing business. I have collected through a variety of means over 100 patents, 101 to be specific, during my career. And I've also worked internally in large corporations, HP and Iron Mountain, for example, in governance roles about intellectual property, deciding what to be patented, patent strategies, and related activities, a lot of interaction with the legal department. So that's my background, and we'll talk a little about patents today. Standard disclaimer, I'm not an attorney and I cannot give you legal advice, and I'll never tell you I'm doing that. In this video, what I'm going to do is express opinions that I've learned over my career and interactions that I have had in the past. And I'll just tell you, it is my opinion, it's always wise to consult with attorneys, legal professionals about any matters legal, and patents are legal instruments. They're backed up by the legal apparatus and systems within the countries in which they're enforceable. So you'll need to go to the lawyers to find out the legal aspects of advice. That said, I am going to give you my opinions about some things I've learned about patents, ways to think about them, and hopefully it'll be practical and help you all as you're inventing and bringing new businesses up in the air. Let me go back just a little bit, and I'll define intellectual property first, and then talk a little about types of patents, and we'll dive into it. So intellectual property is basically knowledge that can be possessed in an advantageous way. And this includes patents, trademarks, copyrights, trade secrets, and industrial designs. I'm going to talk about patents today, and I can talk about some of the other topics in other videos if people find those interesting. Specifically in patents, there's three main types of patents. There's utility patents that just cover a functionality, like a process or a chemical or a particular way to capture image data and determine what's going on in it. Apparatus, things like that. Those are the most of the patents that people are familiar with. Another type of patent is a design patent that protects the way something looks, ornamental features that are non-functional, and I'm going to leave those out of the discussion for today. And the last type of patents are plant patents, and they're specific, and they give specific protection. They kind of operate differently than the other two types of patents, so I'm also not going to discuss those today. So at a high level, there's three things I'm going to talk to you about today. Patents are property. Each patent has a role, like a person has a job has a role, job descriptions, and that's a role within a company or an economic environment. And a patent value is determined externally. It's actually not something that you decide how much a patent is worth. It's the world will tell you what it's worth after it's created. So that makes it a bit tricky to manage and decide what you want to do with them. So we'll dive into these three topics in sequence, and then I'll wrap up at the end. And finally, I'll suggest some other topics I might talk about and hope to get your feedback on things you'd like to learn about related to intellectual property and patents. So patents are property. First thing about property is it can be, well, they can be created with some cost. It takes time to come up with an invention, figure out if it works, document it, just convince somebody that in your organization or yourself that you're going to pay the time and money to get the patent issued if it can go that far. Probably hire attorneys to draft patent applications, interactions with the patent office. When it's all said and done, it can cost in the neighborhood of $30,000 to get a patent issued. I think the kind of quantum unit of money you're dealing with for planning is tens of thousands, 1/10s, 2/10s, 3/10s, maybe as much as 5/10s over the life of a patent to maintain it, keep it active and enforceable if it's valuable over 20 years. What do you get back for this? You get, and patents are chartered in the US Constitution, the inventors get back, if they get a patent issued, a right to stop someone from doing something, from using their product. That's their feature that they patented. And that's the kind of power of it. A lot of people think that patents give you permission to do something. It actually works the other way around. Patents give you permission to stop someone from doing something. And what you can stop them from doing is exactly, specifically, and only what was outlined within the patent itself that's been issued. I'll go into that more in just a second. The ownership of patents can be transferred. They call it the assignee, are the parties that have the rights to the patent. They can practice it themselves. They can just sit on it and not do anything. They can try to stop other people from practicing it and enforce it. They can sell it. They can license it. There are a lot of options. You can take advantage of this ownership broadly. You could license someone the rights to use this patent for lawnmowers and gardening equipment in the United States, but tell them the same patent that might be about engine management for any other applications besides gardening equipment for small engines they're not licensed to use that, because you're going to license that to someone else or use that for your own business purposes. So I said patents are not tools that give you permission, they're tools to stop people. There are two parts to a patent document, principal parts. There's a part up front called a specification. It includes the pictures, like the images, whoops, that you see here, and usually a whole bunch of text and figures explaining. It has to teach someone how to make a functional embodiment of the invention that's being covered. It has to give away that much information. And then there's a second part of the patent called claims. And that's where you define exactly not how the invention works, but what it is, so that someone could be tested objectively and you could determine if they were practicing your invention. The claim might say that a cart has so many wheels. It has 2 sensors to detect if it's going to collide with something, and a microprocessor to stop it moving if something's detected within a distance. That's fine if someone builds a cart with 4 wheels or a cart with 1 sensor that does the same thing. It's probably not read on by the claims of the first patent. So that would be an alternate way that someone could still produce a competitive product, a cart that would move autonomously and not bump into things. So it's very important to understand that the claims are what define if something is or isn't stoppable when you see someone doing it, and the required specification has to teach somebody how to make an embodiment that would support all of the claims in the patent. So again, they're created at a cost. It can be quite high. You can transfer ownership in whole or part. And that also means that if you don't have intellectual property in the form of a patent, you might buy or license it rather than create it on your own. It's a business decision that can be made. And finally, patents are tools that let you stop somebody from doing something. There are a lot of similarities between the way patents work and music ownership. They're not identical by any means, but if you create a song, you can get a copyright protection. You don't really know the value of that work until it's put in the market, and either people find it popular and want to listen to it and buy the digital rights or see performances, or maybe the song's a flop. You could sell the rights before it had been put in the market, and someone would be making a speculative purchase. If the song was tested and a hit, Bob Dylan recently sold rights to a huge portion of his music collection, which is every day gets a lot of listening at some level. So the people buying that had a good idea of what it was worth because the market had valued it. And similar to copyright ownership to rights to a song, it can be enforced through a legal system. You can say these people are using my thing that I own and they need to be stopped. It costs money to take legal action. So having a patent doesn't give you a free way to make someone stop. It gives you probably an expensive way to try to get somebody to stop. Little fuzzier on how you tell if song A is stolen or copied from song B. What if one note is changed, it's probably not enough and it would still be entangled. The claims in a patent are extremely specific. And if the claim says there are 3 of these things in the final apparatus and you do it with 2 or 4, you're not doing what the claim said, and you're probably free to go. So the language of claims, again, you're going to need attorneys to help you construct it, to have it be as broad and protective as possible, and also specific in the ways that's best for idea and what you want it to do. So getting towards ideas and what they want to do, let me go to the second part of second main topic, roles for patents. And I think of these, if you're planning a company, whether it's a board of directors, executive team, engineering or marketing department, well, we need a head, we need some people to do this, we might need some people in the field, some strategists, and so on to either put an assembly line together or put a marketing programs together or whatever is required. Well, patents have roles. They're assets, and you shouldn't just think, I want a lot of them. They're expensive. Every one that you acquire or get, you make on your own and push through the process, came at an opportunity cost because you could have spent the resources that got you the patent on something else. You need to know why you have them. There's other ways to look at it. At a high level, I found this simple three-corner triangle, that's redundant, the simple three-element model for breaking down patent roles to be quite useful. One is differentiation. You can use patents to put a product that has a feature in the market that you don't want someone to copy. You want to differentiate your product. So you have, again, this cart that will automatically stop and not bump into things. Maybe nothing like that exists at the time. Solves a real problem. People don't want to use the carts that bump into things, even though the automation could be beneficial. You get this patent and your intent is that it will stop other people from making carts like this, or from at least using the exact way you did it to make an automated cart that would stop and not bump into folks. Product differentiation. Another way you can use patents is monetization. You could license patents out. You may never want to bring a product. You might decide, I'm made an invention, it's pretty valuable, I don't want to manufacture it, I'll license it to somebody else and make money off the royalties. Completely fair. You may, as I illustrated in the other example, license out partial rights like on a field of use where you're not going to be competing, or in a geographic region. Maybe you get patents in the United States and you're regional and you're working in the Northeast, and you allow someone to practice and use your invention west of the Mississippi River, in the western half of the continent. It's an option that you would have. Another is freedom to operate. Sometimes if you're in business, and I'll call this a symptom of success, your business gets large, starts making some money, large enough, looking exciting, and someone comes and files a suit against you and says, hey, you violated a patent or a trademark that we have, and we want you to stop doing that. It can become expensive litigation. It can harm your business prospects. It could lower value of your company, could scare off investors. But perhaps you have some patents that the other company is either practicing or would definitely find valuable. You've looked at what they do and you know they would like to be able to do some things this way. You might come to an agreement and say, well, how about if we don't litigate these patents against you, you don't litigate these patents against us, you come up with a contract for that and decide that you can move forward. Or maybe it doesn't even come to a contractual agreement, it's just kind of a showing of how many patents you have of interest to the other party, and people decide to settle, or sometimes they'll cross-license. It's a cross-license agreement is generally what this is termed. You might allow them to use some of your intellectual property. They would allow you to use some of theirs. The thought potentially being that both companies would decide it's better for us not to compete and fight over this, or not to fight legally over these aspects, but to compete in the market and try to bring better solutions to the customers. Well, if you don't have any IP of interest to another party, then you lose a certain type of leverage for freedom to operate. I drew this as a triangle. Patents will generally kind of have one of these roles or two of these roles more, and maybe not all three full on at the same time. It's magic if a patent can do all three things for you, but that's like a one individual that can do the job of three. It's kind of rare. What the role for a patent is can shift over time. You may be using a patent to differentiate a line of products, and perhaps you decide to move your business and pivot to a different line of products. And you say, well, I don't really need that intellectual property anymore. I'm moving from home products, for home cleaning projects, to large scale commercial cleaning stuff, and it just doesn't apply. You may sell or license out the IP that is no longer of interest. And for 5 years, it was differentiating your products. And now you've given that individual, that patent, a different role in your organization. And its role is help us have freedom to operate. Or sorry, help us get monetization. I'm going to license it. Or maybe it's a freedom to operate. It's you don't need it anymore. You're not going to put it in your products. But there's other companies that would like this, and then you can use this as a bargaining chip. So different roles for the patents in your company. And you're seeing now I'm talking a lot about business. So we're going to get into value of patents here now. That's the third part. I said value is determined externally. So I asked ChatGPT to draw me a picture of a bunch of traders screaming and yelling at each other in a pit, trading options or futures for commodities or something. And the picture is kind of humorous, but what I'm trying to illustrate is you don't really know what a patent is worth until it gets out in the world and tested. Someone may come to you and say, well, you have this patent, but we believe there's prior art. We believe someone had already invented this same idea 12 years before you got your patent issued. We're going to use this and try to, if it's brought up to the patent office under the proper processes, you can invalidate someone's patent. If it's proven that the idea had been invented before, then it wasn't novel at the time of invention. Patent just evaporates, instantly turns from a valuable asset into dust, essentially. So if a patent gets tested and people attack it and it withstands attacks, then it's very robust. You know that it's solid and that prior art doesn't exist and there aren't any mistakes in the way the claims are written and so on. So that's nice that it goes out and it becomes battle tested. If people buy the products, if people come to you and want to get it licensed, those are evidence that the market is putting value on it. If you're able to enter in a cross-license negotiation with a few patents and get a good set of valuable commodities, concessions, currencies traded in the transaction, then you know that what you had was of value to someone else because they were willing to give something valuable to you back in exchange for it. So that means it's a bit of speculation. When you're deciding to invest in patents and getting them, it's sort of like stocks. You do your diligence, you try to be smart, you don't exactly know how they're going to go. So you perhaps, it's been my experience that kind of a portfolio approach to managing patents that you have, patents you want to get in the future, or intellectual property, and whether you want to sell or license, is that's kind of the way to look at it. So they're a little more speculative than a certain thing. It's not like putting money in a CD where you know what you're going to get, the return you're going to get. The value really then comes from what the claims in the patent read on. Specifically, what does this patent, if you had it, what would it allow you to stop being practiced by someone else? And the other part, the specification, it can have ramifications and such, but the claim or the meat, they're the stick that you can use to stop people from doing things. The second huge contributor value is as I had said, is the perspective of outsiders, not people in your company, but folks that you either do business with, your clients, your customers, supply chains, folks you might cross-license with, someone that you want to try to license it to. Their perspectives about what the specific set of claims in the patent will read on and would allow someone to stop being done. That's the biggest drivers in the value. And I put third, and not in bold on purpose, technical sophistication. It's great to have patents on things that are sophisticated. There's nothing wrong with that. And it's important to keep in mind the value of a patent on something sophisticated will be in the end based on the claims that it can support and what you can do with those claims. And for example, if you patent a very sophisticated way of having a robotic cart not collide with someone, and someone comes up with a different way that's simpler and just as effective, then the fact that your solution was sophisticated really isn't valuable anymore. Now, if the only way to get in somewhere and get something done is with a sophisticated solution, you crack the nut. That's a high barrier to entry, figuring out how to solve something that there's no easy way to do. But there are a lot of workarounds and a lot of ways that clever people can figure simpler ways to do stuff once they've seen that it can be done with a more complicated technique. So these are kind of my priorities. And in another video, I'll talk more about the strategy of a patent and how to develop them where you want. And the fact that I really think you generally, one way to think of it is write the claims first. This is what you want it to do, and then try to back it up with the supporting invention in the spec. It's a little backwards from the way people usually arrive at having an invention, but it's perhaps a better way to approach documenting it and codifying your handle on it and using it as an economic tool through creating a patent and investing in it. So what did I say? I said patents are property. It can be created, it can be licensed, it can be bought, it can be sold. It's property that allows the owner, not the inventor, the owner, because the ownership can be transferred, to do something, and that's to stop someone from practicing the specific set of items that are outlined in the claims of the patent. Each patent has a role, a reason that someone would either want to license it or own it or license it outward. And the patent value is determined externally by others, by the influence it has on them and the behaviors or business practices that they would need to put in place. So the big picture is the patent's a legal instrument. It has a lot of technology involved probably in creating it, but its value to the company and strategically how it's wielded is a bunch of business decisions. So in the end, you have to have business leadership, technical leadership, and legal all holding hands, another triangle again, to really arrive at an effective patent strategy and to use these tools well for your company. So thank you very much. Again, Will Allen, and appreciate your listening and getting this far to the end of the video. I'm super excited about Alchemist Accelerator. I listed a bunch of topics here. So there's two values to this list. One, it's mostly the stuff I didn't talk about today. So I left a lot of things out, just trying to make an intro snapshot. And two, it's a list of topics I would be thrilled to make other videos on or have direct interactions with any of you in your endeavors and elaborate on. So I'll hope to get a lot of feedback on what I could do in the future, feedback on this. Is it a good format? Would you like something else, more of this, less of that? Thank you so much. Have a great day.